The other majority judges comments that it is for the legislature to determine whether these laws should be amended or repealed or whatever. She said that constitutional review is the province of courts, and the court cannot shy away from its right and its obligation to remedy constitutional violations. Then she all went on to the 1967 Loving case where, despite many states having repealed anti-miscegenation laws, and what she's implying is that had the court not ruled in favor of the plaintiffs in that case, the New York state may actually repeal it. The court still went ahead to change the law and repeal it on its own accord. Well, that's basically the New York case, and so the upshot of this is because of the majority's decision that only rational basis scrutiny is required for both reviews, the plaintiff's case did not succeed because it passed under the majority opinion's review that there is a legitimate interest to be advanced, which is to provide a conducive environment for the upbringing of children, and that the ideal family model is for a child that has a male and a female as parents. Now, the Massachusetts position was in Goodrich, the Department of Public Health, in 2003. Remember, this is earlier than the Fernandez. Fernandez was decided just last month. This was in 2003. This is the Massachusetts position. The majority judges in that case rejected the notion that the primary purpose of marriage was procreation, and said that the purpose of marriage is the desire for couples to expressly express their commitment to one another publicly, which is something which Justice Kaye, the dissenting judge in the Netherlands, agreed with. And it was a 4-3 majority decision, so it was not so strong, but 4-3 went through. He decided that the right to marry, the fundamental right is the right to marry someone of any sex. And therefore it includes the right to marry someone of the same sex. And insofar as the law did not allow that, they had to reinterpret the law. So what they did was, marriage was not defined in the law, so they went back to common law principles. So they redefined marriage to mean the voluntary union of two persons as spouses to the exclusion of all others. And this remains the law in Massachusetts today. Okay, coming down to the Singapore position, I'm just going to briefly go through. These are the two equivalent laws in Singapore for due process and equal protection. Liberty of the person is Article 9 of the Constitution, which states, no person shall be deprived of his life or personal liberty save in accordance with law. And equal protection is under Article 12, which is all persons are equal before the law and under the equal protection law, except as expressly authorized by this Constitution that there shall no discrimination against citizens of Singapore on the ground only of religion, race, descent, or place, and the rest is not relevant for the purpose of this law. So basically you can see under the supposed fundamental rights clause, basically no person shall be deprived of his life or personal liberty save in accordance with law. So as long as law provides for it, then it's not unconstitutional. Now, so far the Singapore courts shy away from interpreting this as any larger than that. And they usually defer to the Parliament, I would say entirely, as the history of case law shows. And again, for equal protection, you'll see that there's no prohibition for discrimination on the ground of sexual orientation. And again, the courts do not interpret this purposely or what have you to say that it does include. So it's actually, from my experience, really dead letter as far as Singapore is concerned. Now, what is the Singapore Bureau of Domestic Relations Law? It is the Women's Charter. You note that it's a Women's Charter, so men's rights are not protected. It's just women's rights. So I don't know about lesbian marriage, maybe it can be protected, but gay marriage is definitely out of the scope. Alright? Now, Section 12 of the Women's Charter says, a marriage solemnized in Singapore and elsewhere between persons who, at the date of the marriage, are not respectively male and female shall be void. So there is your short and sweet answer to the Singapore position. It's not been it's not been contested or argued, litigated in courts as far as I'm aware. And for purposes of background knowledge, the Women's Charter was enacted in 1961. This clause wasn't there. It was only included in 1996, together with clauses which define the sex of the person and the sex in your IC. Now, these provisions were put in to reverse a High Court case in the early 90s called Lim versus York that said that transgender marriages are void. What happened in that case was that a person changed sex, I think, from female to male and married his girlfriend. And the judge in that case said that it is void. The parliament was of the view that it shouldn't be void, and therefore changed the law proactively for future marriages, and put this down to clarify the situation. So you can see that in enhancing the rights of transgender parties to marry, the legislature actually entrenched the position of same-sex couples not to marry. In conclusion, what I would say is that there is a worldwide trend, as you may or may not know, that in certain states in the US and in some European countries, there is a trend towards recognizing same-sex marriages. The UK has just recently passed a civil partnership law, but I seriously doubt they will recognize in Singapore because of Section 12. So, whatever progress that happens faster in personal relations due to more open debate, more liberalized thinking. Do I think Singapore will reach there? I would say not in the immediate future, but they may eventually follow suit depending on how other countries continue to do. So it's a very new development, recognizing same-sex marriages. It's only about 10 to 15 years of vintage. So it remains to be seen, but not in the foreseeable future, I would say, in the next 20 or 30 years. I think I've reached the end of my talk.